and welcome back to my channel Igama AsandaNtini, and welcome to today's video. So today we are speaking all things Miss Nandip as Lelo would say. Anyways, let's get into today's video. Context, this is my channel. I am an admitted attorney, but none of my videos form any part of legal advice, legal what. If you are looking for that, please consult with an attorney who's practicing and who is at a point of giving you advice. You get? All right. Anyways, let us speak about this lady. So yesterday, as all expected, as I had predicted, as I predicted, we saw Uguti, the application was dismissed, and obviously, I have now blue glasses instead of green, so the light is now green instead of blue, so I don't know how we'll ever fix this. Okay, I'm blind, so like guys, I can't help with this light thing. Anyways, so the judgment of Nandipha's application, where she said she was abducted, extradited, and what else did she say? And then she said her arrest should be then declared unlawful, and whatever those things that she said she should be done, and then she should her charges should just be set aside. Wildest application I've seen. And then obviously it was firstly postponed because one, they didn't join people that got them from the country that they're saying that they were extradited from. Why didn't you cite people that were directly, like, those are the people that you first deal with? Like, Home Affairs is the one that got you here, immigration is the one that got you here, migration or immigration, whatever that department of Home Affairs got you there. So why are you involving people that were not really, like NPA? I don't get why was NPA cited. Well, it can be cited in terms of setting aside the charges, but then okay, siyakuzwa, but then why not cite Home Affairs first, because they are the ones who actually got you there, who got you from there. Anyways, be that as it may, even if you are alleging that actually I was not taken by Home Affairs, but then they have to be there because they were there. Anyways, that was fixed, and then there was this application. If you want to watch it, I didn't watch the whole thing, it was 5 hours long. The only thing that I did watch all of was the judgment, because as much as I was seeing on Twitter earlier, like on the day yesterday, I was like, I don't want to watch all of my news on Twitter, just wanted to see, okay, is this thing dismissed or not? Then I went and watched the judgment. The application was dismissed as expected, and one of the reasons why it was dismissed was the fact that she consented to being brought back, which is one of the things that you're like, okay, the judge agrees with the fact that, okay, it was extradition. Okay, but then with that said, she did agree to come back. What did she think was going to happen? Like, you went away from this country, running away from crime. What did you think was going to happen? Yes, two countries agreed with us. All right, as it happened, the processes of deportation did not take place as they normally would. Okay. But what did you think will happen when you were being brought back to a country where there is a warrant of your arrest? Did you think when you get there, the warrant of arrest will be frozen because you said you wanted to see your children? Or will it be forgotten about because, okay, you agreed to come back? I don't get it. Like, make it make sense. Anyways, that application was dismissed. Now, it brings me back to my question. Okay, you go to a civil court, a court where the test is different. Civil court tests balance of probabilities. Even if you are going to the high court, you went to a civil court. You went to a civil court, made a civil application to set aside your arrest, which is in a criminal court. attorneys, well, legal practitioners, explain to me why did this become such a fruitful thing to do? Well, the applications like unlawful arrest, all of this, we usually do them once a matter is finalized. Or, as I knew it, like most of the time, if you are declaring an arrest unlawful, once the criminal proceedings have been completed, you then sue the state for an unlawful arrest and claim whatever amount that you could have claimed, you were gonna claim, because maybe charges were withdrawn and all of that. But you do that later, not to say that I'm doing this so that you remove the criminal proceedings, so that the criminal proceedings are cancelled. I've never heard of that. Maybe it happens. I've never seen it. It doesn't make sense to me, because you are bringing an application which is going to be weighed on balance of probabilities against a case that deals with reasonable doubt and understanding. And also, if you're going to use that, will it help in your case? The fact that you agreed to come back, and you even saying the way that you were brought there, you're already confessing to committing crimes. Like Weka, Logo, who I think she's also charged with. She said that Bahambile in her affidavit. So one of that application would have made sense to me. As fun, we litigate differently, and I'm no longer in practice, so I shouldn't speak that much. Maybe things have changed. I don't know how could things have changed in such a short space of time. This application I would advise my client to do later. It's okay, we'll do this application. You're saying this is what happened. Okay, we'll do this application, we'll sue the state, and you are likely to win in that, because they would have found that, okay, yes, she was extradited. And then obviously, probably, likely, it's okay, too okay. But then to set aside the whole thing, that was a waste of time. This whole application, I said it even last time, attorneys should be careful on bringing what's this word? Frivolous applications to court. I didn't even mention the case of the labor case court, that where people were striking and they decided they want to appeal the dismissals, and saying that they were not striking, they were just standing. An attorney even taking that instruction to me says, like, why are you doing that? Okay, maybe imali, I get that, but still, like, come on, man. I'd like tell your client to Moshe's cut, and they're wasting the court's time. And when you're wasting the court's time, one of the punishments that you get is to pay for fees of about, I hope she was advised of that before the whole application took place, because she now has to pay for counsels. And if she appeals, the appeal is likely to be thrown out. Which brings me to my final question in all of this. Okay, Nandip, your attorney says, okay, let's go and appeal this thing. Or your attorney says, okay, let's do this application. What are your expectations? That we're just going to forget that when you helped TP? The court is just going to say, okay, this person, the High Court said that she was not taken lawfully, so we're just gonna forget that she's a criminal who is charged of this and this and this and this, and okay, worst case scenario, which would never happen, did she think maybe she was going to be taken back to Tanzania and then be brought back lawfully? Like, I honestly do not understand what's the theory of bringing this application. You can bring this application, but bringing it now, I don't know. And also, judges when judges make decisions, they have to make decisions that can actually function. They have to make decisions that can actually work. What was the decision of Uguti Ubuyela unlawful, so akaphindele emuva? You can't apply that judgment. If she had gotten what she wanted, it's okay, let's set aside, not set aside, that was not going to happen. You're not going to set aside a criminal charges in a civil court unless you are appealing. Even in an appeal process, you are appealing to a criminal court in the Supreme Court, in criminal procedure in a civil court, not appealing with civil court. Like, I don't understand. So what was the thought? Judgment. It's just basically a moot exercise. I felt that it was just a moot exercise, Great for international law, going to be asked all of these questions. I can already see second semester international law students getting questions about deportation and extradition. What's the difference? You cite this case. But in terms of it being an applicable case in the case specifically of this lady, nah, fam, nah. I think it was just a moot, unnecessary thing that was done to satisfy her ego, and she was so confident, she was so cocky to like you could see in her, nah, she knows I'm going home. Waste of court's time. Like when we are now arguing her bail, saying that no, she abided, she's somebody who wanted to go to court. This person has just wasted a whole 2-3 weeks, a whole 2 days of our time, delayed our time. Her bail application could have been heard with the rest of the other accused, finalized, ahlale jele if bail is denied, moved on, continue with other stuff, stop being making a court stay and wait for our applications are fruitless. I honestly do not know what I would do with that client, because at the end of the day, we are creatures of instruction as attorneys, and you have to obviously advise your client, because this is a waste of time, this is what could come out of this, but because you said this is how I should act, this is how I would act. And also our ethics rules and all of it says very well, but see, the interest of your clients should not outweigh your duty to the court. So Lapaya, obviously, when you look at that duties of you as an officer of the court, you look at like you lying under oath, all of that. I don't think that happened. But the wasting of time is happening in so many ways, because people now just want to litigate, people want to take things to court, and unfortunately practitioners are taking these instructions and just doing moot exercises in courts. Applications are dismissed day after day. It's just a waste of time. It's just a waste of time. Anyways, that's my 2 cents in that. And yeah, my thoughts are that yes, the application should have been dismissed. I'm glad that it's dismissed. Happy to hear that. And also, if it was not dismissed, I don't even think the judgment would have functioned, because let's just put law aside. What was the logical thing that was going to happen? We're going to take her and put her next to that Namibian border and say, okay, South Africa, then we charge you again. We throw the charges and then put them back again. Make it make sense. What was the thought process around the whole thing? Anyways, that was my rant. Look at my earrings. Like, it's cat earrings. Love them. Got them from Tiffany. Not Tiffany's, the store. Tiffany, my friend, got them from Lovisa for me. I'll show you a picture. Yeah, love them. With that said, thank you for watching. I will see you on my next video, and stop wasting court's time. Whatever you do this week, if you are accepting instructions as an attorney, if you are accepting instructions on behalf of your firm as a candidate attorney, think about the time you are wasting for court. Think about how moot these exercises you are doing are. Thank you for watching. I'll see you next time.